Today, we need to talk about something the Trump administration did while you were traveling, cooking, or trying not to scream into a pillow. They quietly gutted the Endangered Species Act. Not revisited, not updated, gutted. Like a poacher who saw a rhino and said, ooh, what if this was a regulation? And they did it in the sneakiest way possible by releasing 4 federal rules right before the holidays. It's Washington's version of burying a body under your Christmas lights and hoping nobody checks until February. Here's what those rules actually do. 1. They change how species get listed, making it way harder to save them. For 50 years, ESA listings were strictly scientific. Now, political appointees can say, saving the species might mildly annoy a developer, and boom, extinction gets fast-tracked. 2. They strip automatic protections from threatened species. For half a century, threatened meant protected. Now it means, we'll get back to you if we feel like it. It's basically wildlife Hunger Games, and the Interior Department is Caesar Flickerman. 3. They weaken habitat protections into oblivion. They change the definition of habitat so narrowly that if an ecosystem is degraded, it no longer counts as habitat. So if a species needs restoration, too bad. Under this rule, if it's destroyed, the ecological equivalent of, if you loved your house so much, why did you let developers bulldoze it? 4. They make it easier for agencies and corporations to dodge ESA protections entirely. They rewrote consultation rules so developers, mining companies, and federal agencies can essentially rubber stamp their own projects without serious review. It's like letting a fox do the home inspection on the henhouse. These rules openly violate the Endangered Species Act. The administration knows that. But they also know the Supreme Court now guards deregulation like it's an endangered oil rig. And here's the real horror movie twist. Even illegal rules stay in effect unless courts block them immediately. And this Supreme Court treats environmental oversight like it's a personal insult. So yeah, a president can now violate federal law through regulation and keep violating it for years while litigation crawls forward at the speed of sedated tortoises. And here's the part they prayed you wouldn't notice. The public comment period is open right now. They dropped these rules right before the holidays because they're counting on exhaustion, distraction, and the emotional damage of spending 4 days with relatives who don't see why ESA matters, sweetie. If we sleep through this, they win. Here's the truth. No NGO wants to say out loud, the agency's not going to read your comment. That's not the point. Your comment becomes part of the legal record. And the legal record becomes the foundation for lawsuits, the only tool left between these rules and irreversible ecological collapse. When a judge eventually reviews this mess in 6 months or 6 years, they will ask, did the agency ignore science? Did they contradict the law? Did they disregard public warnings? And that's where your comment becomes evidence. A lawyer will hold it up and say, the public told them, they ignored everyone. So here's your call to action. Go to the Federal Register, find the 4 ESA rulemakings, paste your comment, even 1 sentence counts. Hit submit. Be part of the legal record. If the administration is determined to break the law, history should show you didn't help them do it. And generations from now, when your great-grandkids visit whatever nature still exists, they'll know at least one person in their family actually tried.